Good afternoon, everyone, and thank you for joining us for this webinar presented by AIA Contract Documents titled, When Disaster Strikes, How Do AIA Contract Documents Address COVID-19 Issues? Over the next hour and a half or so, we're going to be talking about a number of issues that have been popping up in the construction and design industry. We know a lot of you out there who are listening to this webinar have been experiencing numerous disruptions with your projects, with your workflow. We've been hearing from folks all over the country that there are numerous mandatory work stoppages on projects. There are voluntary work stoppages as well that are happening. In addition to that, we know that a lot of folks are experiencing difficulties with getting materials and equipment and other supplies on your job site that 2 months ago might have been relatively easy to obtain. We also know that as things progress here over the next few months, it's likely that you're going to have issues with your workforce. It's possible that folks are starting to get sick on your workforce, and that's going to be causing you some stress as well. And thinking a little bit further afield, it's entirely possible that owners who are still in the conceptual and design phases of a project will begin to perhaps even rethink projects that have not started construction yet. It's perhaps projects that might have sounded like a good idea 2 months ago don't sound so good anymore as far from an owner's perspective. So we're going to be talking about all of these issues in the context of primarily of two AIA contract documents. From the owner contractor perspective, we're going to be talking about the A201 general conditions of the construction contract. And then towards the back half, or probably the last half an hour of this presentation, we're going to be talking about owner architect issues. And we're going to be talking in the context of the B101-2017 owner architect agreement. Now, we do offer a number of owner contractor and owner architect agreements, and we'll try to, if you are using an A105 or a B105, we'll try to let you know how these issues are handled in those contracts throughout the program. But by and large, the issues that are going to be present in A201 and B101 do carry out through most of our owner architect and owner contractor agreements. So you'll find a lot of commonalities there. So we've flagged what we think are kind of the top 7 or 8 issues for owner contractors and owner and architect agreements. And we're going to talk about them in some depth here and start to show a lot of contract language on our screen and talk through those issues. But we want to hear from you. We want to know the unique issues that you're facing as well. If you have some issues that you'd like us to talk about, please send us a question in the GoToWebinar little dialog box on the right-hand side of your screen. Let us know what issues you're facing, because we might be able to address them in some manner. And if we can't get to them on this webinar, we might do another one as well and address some of those unique issues. Next slide, please. A couple of housekeeping items to talk about. This program has been credited for 1.5 health, safety, and welfare learning units. So if you are an AIA member and you've registered for this program properly, you should be seeing those on your transcripts here in about 2 weeks. It does take a couple of weeks of lag time. In addition to that, if you're having any audio problems, it's been our experience that those tend to pop up if you're trying to use your computer's audio and microphone and speaker. It's probably best, if you're having audio problems, check to make sure that you're using a phone or dial into the webinar. You'll usually get a cleaner signal there. And lastly, we are going to be sending out this PowerPoint that we're going to be going over. And also, we're going to be sending out the recording of this webinar. So I need to now talk about one big disclaimer. And I'm going to spend a few minutes on this disclaimer because I think it's really important in the context of these issues that we're all facing. While myself and my co-presenter, we're both attorneys, we can't provide any legal advice. We can tell you about the AIA contract documents. We can walk you through, how those documents work and the intention of them. But it's really what we're going to be saying here over the next 90 minutes or so is no substitution for consulting with a local attorney in your area who can understand your contracts and understand, the very nuanced issues that you're going through. So just a couple of examples about that. Right now, over the course of the next 90 minutes or so, we're going to be flashing up a lot of language on the screen that is all standard AIA, unedited language from our A201 and our B101. It's very possible, if you are following along from home, that you're looking at a version of the document that's been edited or modified during negotiations. It's also possible you're looking at an older version from 2007 that might be worded a little bit differently. So just pay attention to that. And also to the fact that while it seems like we're all experiencing similar problems on our projects uniformly throughout the country, that's really not the case. At least if Google is to be believed, and in the news that we've been following, we know some states and some cities have bans on construction projects and have called for mandatory work stoppages, but other cities and other states are allowing projects to go forward. So your experience and the kind of issues that you're going through are going to vary. So that's why we feel it's really important to talk to someone, a local attorney, if you have any follow-up questions to the material that we're going to present. Next slide, please. Okay, so I haven't introduced myself, which I'll remedy that right now. My name is Mike Koger. I am a staff attorney with the American Institute of Architects. I've been with the AIA for about 7 years now. And my day job is to do things like this, give webinars, research legal issues pertaining to the AIA's contract documents. I work with a few other attorneys on our team, as well as a excellent volunteer group of architects from all over the country who really are the lifeblood of our contract documents program. I started off my career as an architect. I did work for about 5 years in the field and doing architecture work in Southern California. Went all the way through, got my license, practiced for another year or so after that, and then ended up going back to law school, and I worked in private practice after the last recession that we had for a few years, doing construction defect claims for a few years before starting to work for the AIA. Joining me on this presentation is Jimmy Germano. Jimmy and I used to work down the hall from each other. We now are working from our own respective homes. And I should say, on a personal note, I have somewhere in my house, I have a 3.5-year-old little girl who is very curious, and I barricaded myself in a room, and hopefully I will be able to do this presentation without any major interruptions. But she's really good with doors and really good at jumping over barriers. So who knows? We may have some comedy interspersed here. Jimmy, I'm going to turn it over to you now, and you can tell us, please, a little bit about yourself. But before you do that, make sure you let us know how you're doing. Are you staying healthy? And what Netflix shows have you been binge watching?
Sure. Thanks, Mike. I appreciate that. I am staying healthy. We are, usually we're maybe 50 feet apart in the office. Now we're probably 8 or 10 miles on the other sides of DC. Like Mike said, I work at the AIA as well. I'm a staff attorney. Before working at the AIA, I was a litigator in private practice for about 7 years. Spent most of that time doing construction work, contract negotiation, claims, and litigation, local in the DC area, and representing parties sort of up and down the project chain, suppliers, architects, contractors, subcontractors, and some owners. So sort of without further ado, we're going to jump into the substance and sort of the heart of this presentation right off the bat. Again, like Mike said, feel free to ask questions throughout and we'll try and get them answered. We did receive questions from a number of you before this webinar started. And what we've done is we went back and adjusted the webinar a little bit to try and address some of those questions. So you might see a slide that's directed toward one of the questions you asked. And if at the end we haven't addressed something, then obviously feel free to go ahead and ask it. So let's get started. with a term that you're probably seeing a whole lot of right now, and that is force majeure. So force majeure is a term that a lot of people have been considering and hearing about and reading about lately, and we want to talk about what it is and where it is. And when I say where it is, I mean specifically where in the AIA set of documents it is. So I want to discuss first what it is, and then we'll get to where it is located within the AIA suite of documents. So force majeure is a French term. It literally translates to a superior force. And the thing to understand is at its core, it's a risk allocation principle. It allocates the risk that some superior force is going to interrupt a project in a substantial way. The idea behind a force majeure clause is to embody the following concept. It's that construction contracts anticipate and they have mechanisms in place to apportion risk and then potentially adjust project schedules or contract sums to reallocate those risks and reimburse a party if they're unable to complete their contract obligations due to some circumstances that are out of their control. The thing to understand and what we're going to focus on here in this presentation is a clause does not have to be titled force majeure to do the same thing as a force majeure clause. And over the next couple of slides, I'll explain what I mean by that. And in fact, there's case law from jurisdictions around the country interpreting force majeure clauses narrowly. And what I mean by narrowly is if a force majeure clause sets out a few specific events, such as pandemic or acts of terrorism, acts of war, things like that, a court or a third-party neutral, a jury, is going to look at those clauses very specifically. And unless you set out that specific term, some other very large event may have taken place, but unless it's listed, there are some courts throughout the United States that are going to say it's not going to count as a force majeure. It's not going to trigger a force majeure claim because you didn't specifically list it. And I want to show you what I mean by that. So on your screen right now, you'll see a quote from a case. It's a 1987 case out of New York. And the second sentence of that, this quote here from the decision is the important point that I want to focus on. And that reads, ordinarily, only if the force majeure clause specifically includes the event that actually prevents a party's performance will that party be excused. Meaning, unless you specifically list it in your force majeure clause, it may not rise to the level of being able to trigger a force majeure event. Now, every state is not going to decide this the same way, and you'd have to check your local jurisdiction, check with the local attorney to see if this is in fact the way that your state interprets these types of issues. But just understand this is an event that could come up. This could be something that you have to consider when you're dealing with force majeure type clauses. So having said that, therefore, it can be in all of the parties' interests at the front end when they're in contract negotiations to leave a force majeure clause very broad so that any event, even if in fact it's substantial enough to cause a project delay, can trigger your force majeure rights. So courts sometimes say, you know, if you listed 5 or 6 things, then it's only going to be those 5 or 6 things. But if you didn't list anything and you just said, if there's a delay, you know, et cetera, then that might even be beneficial for the parties in certain situations. Not every situation, of course, because you may have hit the nail on the head, but that is to say there are different ways to structure these types of delay provisions. And sometimes wording them more broadly can actually inure to the benefit of the parties. So that's a little bit about what a force majeure clause is. It's a risk shifting mechanism that allocates risk in the event something happens to delay a project. So we're going to talk a little bit about where it is. And what I mean by that is, where is it located within the AIA document? And the answer is, it's not really. The term force majeure You won't find it in the standard suite of AIA contract documents. But the thing to understand is that the concept, this risk allocation principle for delays out of the party's control, that's present in essentially every single one of the AIA set of documents. And I think Mike had mentioned we're going to go up and down the contract chains and start with owner contractors, and we'll talk a little bit about where we're going to go in terms of the agreements. But one thing to understand is, even if we don't quote or mention specifically by name the agreement that you're using, if you're using an agreement that we don't reference specifically or quote specifically, understand that these concepts and perhaps even this exact language is going to be present in your agreement. You just have to find it. It might be in a slightly different spot, but the concepts that we're going to discuss are going to be present in your agreement. So having said that, let's move to just a quick overview as to where we're going to go from there now that you understand a little bit more about what and where force majeure clauses are. So this webinar, Mike and I, we intend to demonstrate how the AIA's various agreements allocate those delay type risks, things that happen that are out of the party's control, even though the AIA's documents may not use the term force majeure. So we're going to discuss owner contractor agreements, contractor subcontractor agreements, owner architect agreements, and then architect consultant agreements. I want to pause here for a second and note that you might be an architect, right? Or you might be a consultant sitting on the line right now saying, well, okay, the first half of this presentation roughly is not really going to relate to me, so let me check out and I'll come back. Well, we would suggest that it's beneficial for architects and subcontractors and consultants to pay attention to the first half of this presentation, even though we might not be quoting the B and the C series documents, the architect and consultant agreements, because the concepts and the contractual clauses that we're going to discuss and how they work, it applies essentially across the board. So it's important for all parties to understand how these contracts speak to one another and how they operate, because the concepts are essentially the same throughout. So we'll get right into the first topic, and the first topic is something that I'm sure is on top of mind for all of you, and that is contractor delays. So the first way that the COVID-19 epidemic, for example, might impact the project is it causes a delay that is outside of the contractor's control, and they may potentially be unable to finish a project on time. So with that, we're going to go to the first clause that potentially comes into play with COVID-19 issues. That's section 8.3.1 of your A201 2017. Your A201 2017 is a general conditions document. The general conditions document A201 is incorporated by reference into various agreements, usually the A101, A102, and A103, and then it's incorporated by reference either in whole or in part into a number of other agreements. So if you understand first how the A201 works, that's going to check off a large portion of the remaining documents because they're going to incorporate this clause either expressly or implicitly. So what we're going to do here is spend the next couple of minutes breaking down this section because it's important to understand how 8.3.1 works, particularly with respect to delay claims and delay claims that would be quote unquote force majeure type events, even though of course this section doesn't use the phrase force majeure. So if you look at the screen in front of you, what you're seeing is 8.3.1, 8.3.2, and 8.3.3. Let's focus on the first one, 8.3.1. It's one sentence, and what's highlighted in red in front of you are three words: if, then, and shall. So the first thing to understand is 8.3.1 is just a big if-then sentence. If this happens, then this shall happen. And it's important to understand that that's the framework of this sentence because that sort of frames the issues and it lays the backbone of this clause for the remaining issues that might come up. So first, let's talk about some of the other nuances of this clause. So the first thing that has to happen is the contractor has to be delayed at any time. That's the thing that you're seeing on your screen that is highlighted in yellow. if the contractor is delayed at any time in the commencement or progress of the work. So that's the if part of this sentence. So if the contractor is delayed, and then the words commencement or progress are in there simply to mean that the contractor can be delayed during the progress of the work, meaning while the work is ongoing, or in the commencement of the work, meaning maybe the contractor has received there's been a notice to proceed that's been issued, but the contractor can't start work. So the commencement of work has been delayed at any time. So that's the if part of the sentence. Some triggering events that might come into play with the COVID pandemic are here in subsection 3. So subsection 3, what you're seeing some additional highlights on your screen are unusual delays in deliveries, unavoidable casualties, or other causes beyond the contractor's control. So breaking each of those down, what you're seeing is if there's a delay that's caused by or if the contractor is delayed by an unusual delay in delivery. So for example, one example that we've seen a couple of times in some stories that we've heard from contractors and architects and owners is Italian marble, right? So Italian marble deliveries may not be happening at the right place right now or on time. So you may have an unusual delay in those types of deliveries. So if the contractor is delayed by an unusual delay in delivery for example, Italian marble, this 8.3.1 would potentially come into play. An unavoidable casualty is simply, it's sort of a fancy term for accident. That may or may not come into play depending on the circumstances of your particular project. But then the last little couple words of subsection 3 are other causes beyond the contractor's control. And you're seeing that, that's the last section highlighted in yellow. Other causes beyond the contractor's control can mean, like we said earlier, it's very broad. It can mean essentially everything or anything if the contractor is delayed as a result of those other causes. So taking subsection 3, and again, we're getting into some detail here on this clause and we're breaking it down, but that's because we think it'll be helpful for people to understand how this clause works. Let's look at how this clause would read if a contractor is going to rely on these 3 triggering events in subsection 3 for their claim. So it would read, if the contractor is delayed at any time in the commencement or progress of the work by unusual delays in deliveries, unavoidable casualties, or other causes beyond the contractor's control, and you go down to the then the contract time shall be extended for such reasonable time as the architect may determine. So that's your sentence if the contractor is going to rely on subsection 3. The thing to note here before we go on and talk about one last part of this clause is notice that the then is automatic. It's a shall, and we talked about the importance of the word shall. So if the contractor is delayed at any time by another cause beyond the contractor's control or an unusual delay in delivery, then the contract time shall be extended. The only final step at that point is for the architect to determine how much, the quantum essentially of this issue, how much the contract time is going to be delayed, going to be extended. But the fact that the contract time is going to be extended has already occurred because of the way this sentence is structured. One final point about 8.3.1, and that's this subsection 5. Subsection 5 is a little bit more broad. It's more of a catch-all provision. And what subsection 5 says that the contractor can be delayed in the progress of the work by, and here's the highlight, other causes that the contractor asserts and the architect determines justified delay. And it's important to understand the distinction between subsection 5 and then what we just talked about, subsection 3. Here in subsection 5, if you'll notice, the fact that something has to be beyond the contractor's control is not present in subsection 5. But the trade-off is the architect gets involved a little bit earlier. So this clause can be misunderstood to assume that the architect has to get involved a lot earlier than they otherwise would. And if the contractor, for example, in subsection 5, if the contractor says, well, there was a cause that delayed the commencement or progress of the work, but it may have been within the contractor's control. Well, the contractor can still request that even something like that justifies a delay. And if the architect agrees, then you move to the final part of the sentence. So the contractor is delayed at any time by another cause that the contractor asserts and the architect determines justify the delay, then the contract time shall be extended. And then the architect again determines the extent of the delay. So if a contractor is going to rely on subsection 5, then the architect gets involved at the sort of the entitlement phase of the request, whether the contract time is going to be delayed, and also in the quantum phase, how much the contract time is going to be delayed. The reason why we went into that again is to highlight the importance of reading these clauses carefully and understanding how they work. And we would anticipate that 8.3.1 is going to come into play a lot as we see with the COVID-19 epidemic. So bouncing down to 832 and 833, which are the bottom two clauses on your screen. 8.3.2 is there just to remind the parties that they need to look to Article 15, which is your claims and your dispute resolution provisions within A201. We're going to talk about those in just a second. Just to remind people that, yeah, if you're going to make a claim, you have to make it in accordance with the other provisions of your contract, specifically Article 15, but any others that could come into play. 8.3.3 is essentially the opposite of what you would normally consider to be a no damages for delay provision, and it specifically says that 8.3 does not preclude recovery of damages for delay. So we saw a lot of questions in the lead up to this this presentation and otherwise asking, well, 8.3.1, for example, gets you time. A contractor gets time through 831, but perhaps not damages. And 8.3.3 leaves the avenue open for damages for delay. The contractor just has to submit a claim for damages, and we'll talk about how to do that. But notice the slight difference there between the two. So like I said, we're going to talk about Article 15 here briefly, and this is how to adhere to your contract provisions on claims for additional time. So contractors need to be aware and review their contract terms to make sure they comply with these kind of notice requirements. So if the contractor wants to seek additional time, they need to comply with, for example, 15.1.6.1, and that clause says they have to provide notice as set forth in section 15.1.3, which we'll get to next, and their claim should include an estimate of costs and of the probable effect of delay on the progress of the work. Again, with something like this, it's important just to review sections like these to understand what has to be included in your initial claim, when it has to be submitted, where it needs to be submitted, etc. If like we just referenced 15.1.3, so if a contractor wants to submit a claim, these types of issues are going to come up also. So they want to make sure, for example, that claims are submitted timely. The default in 15.131 on your screen is 21 days, and that's 21 days after the occurrence of the event giving rise to the claim, or 21 days after the claimant first recognizes the condition giving rise to the claim, whichever is later. So you definitely want to make sure that as soon as something happens that may trigger a claim, you want to go ahead and get that notice in promptly so you don't waive your right to do so. Section 1.6.2 is an interesting section. Again, obviously it's not in Article 15, it's in Article 1. But it says that notice of claims have to be delivered by certified or registered mail or by a courier providing proof of delivery. Now, of course, like Mike said at the beginning of this presentation, this is just the standard language. The parties could have agreed to different terms. They could have said email is fine. They may have agreed to a digital data protocol or BIM protocol that sets forth different methods of delivery, and it makes that completely appropriate to deliver notice. However, let's take 1.6.2, for example, and just talk about it for like 30 seconds. So you have your claim, you have your notice, you've been delayed, and you're ready to go. You printed it out, you signed it, it's good to go, and the post office is closed. So you can't send something certified or registered mail, or the normal company that you use as a courier is not operating right now. They can't, or there's a suspension of their services or whatever the case may be. It's in those type of issues that are COVID-19 related where the best advice that we can offer in that situation is not legal advice, it's practical advice, and that is communicate with everybody. Just communicate with the other project parties, and we'll talk about the importance of communication later on, that you have something hampering your ability to perform, to adhere to your contract obligations. How do the parties want to proceed? So now we're going to talk about some other ways during the COVID-19 epidemic that this issue might come up. But the thing to understand here is that there are legal mechanisms in place, whether they're in the contract or just sort of general legal principles that come into play when a party is precluded from, it is impossible for them to comply with their contract. What happens? So in those situations, you want to understand your rights, and the best bet is just to consult an attorney who can tell you about legal theories such as commercial impracticability, legal impossibility. Any of those things might come into play. We can't tell you whether or not they would. It's a very fact-specific analysis that would depend on each project, each contract, each situation. So I just want to mention that as an example of one of the type of COVID-19 issues that can come into play on something so simple as sending a certified mailing. And with that, I'm ready to turn it back over to Mike, unless, Mike, you have any questions or anything?
Excellent. Yeah, thank you, Jimmy. That was undoubtedly the most thorough explanation of contractor delay issues in A201 I've ever heard. I think it was really good and obviously very timely. So thanks for going through that in all the detail. But I'm not going to let you off the hook that easy. I got some questions for you. I had time to jot down a few kind of hypotheticals.
Sure.
So I've kind of been forming my ideas about these, but I'm going to give you a chance to let me know your thoughts. We'll see if we agree or disagree. Okay, you ready?
Yeah, let's do it.
Okay, so first one's probably the most straightforward. Let's say I'm a contractor and I'm in a state or a city where I've got my governor or my mayor has mandated that all construction work be shut down, and particularly, my project is shut down as a result. And let's assume that the governor or the mayor has the authority to do that. Do you think that would qualify me for a excusable delay under Section 8.3?
I think that would, in all likelihood. Again, can't be 100% certain because we're lawyers and we have to hedge everything, but I would say in all likelihood, that is the kind of thing that's the most clear-cut example of something that's out of a contractor's control. And you had referenced Section 8.3. If you look to some of our other contracts, for example, like the A105 that a lot of people might be using for residential or smaller projects, you can look to some other sections that look a lot like 8.3, but would give you those same rights if your jurisdiction has shut down work. For example, I think in the A105 it's 11.2, but it would be others throughout the other set of documents. But to answer your question, I think my gut on that is that, yeah, that would be the kind of thing that would trigger a proper delay claim. What do you think about that?
Yeah, I agree with everything you said there. I mean, to me, this is the most black and white example, or issue that I think you could really have with a contractor delay. I mean, it's kind of hard to think of exceptions, or, I like to think that there's an exception to every rule. But in this case, I mean, if I'm a contractor and literally I am mandated that I would have to break a law of some sort to get back on the job to keep it moving forward, that seems like a pretty obvious one to me, that it is a cause beyond the contractor's control. So I think we're thinking alike there. I mean, you could probably present a set of facts that's not true for, but it's hard for me to even think of those, what that might look like. So a counter argument would be tough to come up with. Okay, so I got another one that's a little more nuanced here. Let's say I'm a contractor and I'm still allowed to do work on my project. Like there's not been a mandatory shutdown of all construction work in my area yet, but it's becoming really difficult for me to get materials or equipment. I need a crane or something, or I need actual materials. I just cannot get onto the job site to keep it moving forward. Do you think those kinds of things would qualify for an excusable delay under my A201 agreement?
So I would say that maybe a less confident yes than last time, but perhaps still a yes. My gut would be probably if you have, for example, to quote 8.3.1, if you have an unusual delay in delivery of Italian marble, or you're waiting for scaffolding that's just not arrived yet, and you can't do your work if it's on the critical path, then that would probably be the kind of thing that would fit within 8.3.1. The only additional thought that I had as you were asking that question was this probably raises the issue of mitigation. And mitigation of damages is, we can spend like an hour talking about how it works and when it comes into play. But essentially, what you need to understand is that you, as the party who is being delayed, you have an obligation under the law to continue to work if you can to minimize the cost and the impact of your damages. So even though you might not be at fault for this delay, you have to look around the project and you have to be reasonable and say, well, the scaffolding may not have arrived yet, but is there somewhere else on this project that we could work to minimize the impact that the scaffolding delay has? We have to minimize and mitigate our damages. So that would probably be the only little nuance that I can think of right off the bat that would come into play with that type of issue. Can you think of any others?
No, I agree with everything you said there. I mean, for me, this is one that I just need to know more information. This is where it's this one is very fact specific to me. I don't think we can come up with any black and white, rules here on this one. If we're talking about you literally need a crane to take the project to that next step, then yeah, that's almost certainly an excusable delay under Section 8.3. But if we're, talking about a situation where we're pouring concrete out there for foundations and the windows are delayed or the doors or the hardware is delayed, probably not a very good scenario for getting a real, making a proper delay claim there. So it all depends on, critical path, what avenues have you attempted to mitigate those delays, and those kinds of things. So definitely more of a gray question for me. That depends on your very fact-specific situation. Okay, I got another one, and this one is getting a little bit more interesting for me, because I'm just going to admit right up front, I don't have a great answer for this one. Let's say that you have you're working on a project as a contractor, and there's no mandatory shutdown, but you've been following the news just like everybody else, and the CDC, that there's cases of coronavirus that are present in your area, which seems like they seem to be everywhere in the United States now. And you've been following the news, and you see that the CDC has recommendations out there for things like social distancing, washing your hands, wearing masks potentially, and you're a contractor and you're trying to, and you're responsible for things like job site safety, which has taken on a whole new meaning, I think now. What am I supposed to do as a contractor? And does 8.3 give me an option for a delay due to those things, or just what am I supposed to do in that situation?
Yeah, so I'm trying to think of a good answer as you're asking that question. I don't really have a good answer. I think that this is probably the situation that is the most difficult right now for participants in the construction industry, is that they might be able to work. Maybe they've been deemed essential. They can physically do their job, but there's CDC guidelines and there's risks out there that say that they need to have people 6 feet apart and they can only have 10 people on the job site. Well, does that sort of mean that essentially they can't do their job? It would be the same thing as if the project were shut down, or does it not mean that? Does that mean that they have to go back to work? Right now, there's really no good answer for that question, I think. I haven't been able to sort of come up with one that says in every situation, here's what you have to do. I think in that situation, the best thing to do is just communicate. I mean, you as for example, if you're a subcontractor and you're being told to work, if you have a legitimate concern that you're going to violate CDC guidelines or put your employees at risk, then obviously you can't violate your OSHA regulations for providing a safe work environment for your employees, and you can't violate your contract obligation for job site safety, like you referenced, but at the same time, you have to complete the work. So that's a really difficult issue that a lot of people are being placed in right now. And I think that the contract is not necessarily set up to address that particular situation. So the best thing to do I can think of is just communicate that issue up and down the chain and figure out a solution. What do you think about that? I mean, other than communicating, I really don't know, where you can go.
Yeah. No, this is definitely a tricky one that I think people are obviously facing for the first time. I was thinking about this the other day when I was walking by a project in my neighborhood. So I live in Washington, D.C., kind of in the central part of it. We've got construction projects everywhere around us. And there's one particular project that, it is probably the most fast-paced project I've ever seen. They went from demolishing an older structure to literally doing the groundwork as they're demolishing the other parts of the building. It's probably the quickest demolition to steel frame erection that I've ever seen. And on a normal day when you're walking around that job site, it's just a beehive of activity. And when I was walking around it the other day, I'm noticing, they're not doing this. They're still out there doing work, but they're doing it at a much more modest pace. There's probably a tenth of the employees or workers out there that I had seen in the past. And my guess is what they're doing, which is probably what I think would be the right thing to do in this situation, is they're trying to comply as best as they can with CDC recommendations for social distancing, for cleanliness and those kinds of things, and still keep the project moving forward. So they've obviously made a decision that we can, someone's made a decision that we can keep this project moving safely if we limit the amount of trades that are on the job site. So, and a part and parcel with that is, I hope that someone is documenting on that project and on all these kind of projects that are slowed down, not necessarily stopped because of this, documenting all of the ways in which they're delayed. You can only have 2 trades on the site instead of 10. You're certainly delayed in a manner there, and you're probably incurring some extra costs. So I think that's probably a middle ground that Section 8.31 would work with. I mean, if it does say causes beyond the contractor's control. It doesn't mean either stop or go completely 100% of the pace. If you can do it at a moderate pace while still trying to comply with CDC recommendations, that might be a path forward for folks. I would also encourage any owner who's thinking about doing, or contractor who's thinking about doing that, get owner buy-in and architect buy-in of that before you start modifying your work schedule, of course, and execute a G701 change order and document all your costs, those kinds of things. One last question, and then we're going to move on. Sorry to keep kind of putting you on the hot seat here, but you got any before we move on to the next topic, do you have just 1 or 2 tips that you've been thinking about this for a week or so, because frankly none of us have been able to do anything else except for work and watch TV. What are the 2 top tips for contractors now as they're experiencing delay issues?
That's a great question, and I'm going to plagiarize a little bit. I read an article a couple of days ago, and I forget where I read it, so I'll do it without attribution. So if anybody can figure out where this came from, then let me know, and I'll give them attribution. But it was the 3 C's that can come up right now, and that is consult your contract, consult an attorney, and communicate. And I can't see a better strategy right now than consult your contract language, consult an attorney to figure out what your rights are if the language is too complex, or you just want to make sure you're crossing all your T's, dotting all your I's, and then communicate with the project parties up and down to see. I can't think of a better strategy than that right now, particularly when you're in those gray areas like we talked about a couple of minutes ago. How about you? What do you think would be some good tips for people right now?
I definitely agree with those. I mean, when I was working on projects as an architect years ago, I was very aware that 95% of the difficult issues that we ever had were resolved kind of informally without getting a court or a mediator or an arbitration panel involved. So communication's key. My 2 things would be a little bit different than yours, but it's sort of similar. Whenever pay attention to your notice provisions in your contracts. If you're required to provide notice in a certain way, like we've already talked about, make sure you're doing that to the letters of your contract and doing it right. and you certainly can resolve a lot of things informally, but when you get down to providing notice, do that the right way and comply with all the requirements in your contract. Second thing would be to really document, all costs and all time spent due to delays. I actually read, there's been a lot of articles out there in the construction world over the last couple of days, particularly about how to deal with coronavirus issues that the contractors and architects are facing. I read a really good one from a few attorneys over at Picard and Abramson, and they talked in their article about documenting costs and how to document those costs, extras and overruns due to delays, and really to create a couple of different buckets for all the expenses that you're incurring on a project. What are the things that are very specific due to delays, and what are things that are just kind of your normal costs that you would have incurred anyway? So make sure you can break those things out appropriately when the time comes. Because it's really one thing to be entitled to additional compensation or additional time due to a delay or due to some event, but it's a whole other thing to be able to prove it up in a way that doesn't cause conflict and create ambiguity. It's been my experience in mediations and trials in the past that if you've got, the less supported your claims are to entitlement for extra money and time, the more resistance you're going to get from the other side in actually getting those things. If people are pretty good about their documentation, more often than not, you're going to get a better response from the side that you're looking for money and time from. So anything else we need to talk about delays before we move on? I know we've kind of spent a lot of time on it, but it's obviously the top issue right now. So anything, Jimmy?
No, I think those are all great points, and I think this is top of mind for everyone. So I'm cool spending a little bit more time on it. But at the end of the day, I do think there are some other issues. So I'm cool moving forward. If you think we're ready to go talk about some suspensions and terminations.
Let's do it. So a couple other things. We'll probably be about 20 minutes or so before we actually get into the architect issues. So sorry for those of you architects who are hanging on the phone and just listening to us talk about contractor stuff. We will get there, and if here soon enough. I know we had also several folks wrote in to us that we had some audio issues at the very beginning of this program. Really sorry about that. You all missed my wonderful introduction. So sorry about that. I hope we've got those resolved right now. The next issue that I want to talk about is owners' rights to suspend the project or terminate the construction contract for convenience. We know that owners have been suspending projects voluntarily, even if they are not mandated by a governmental body of some sort. For example, in my own neighborhood, we've got a project in a large university that's been stalled out for a couple of weeks, well before there were any mandatory work stoppages. So owners are already exercising the rights that they have to suspend projects due to health issues. But it's also possible that, like I mentioned at the very top of the hour, that owners could be looking and rethinking their projects holistically. And if 2008 and 2009 is any guide for us in the economic crisis that happened at that time, we know that in times of uncertain financial markets and just uncertainty in general, owners might be rethinking projects that are still in the design phase. So don't be surprised if an owner comes up to you and as an architect or a contractor and says, "Hey, we're gonna terminate your contract for convenience because the assumptions that went into this project 3 months ago are retail projects, for example, are probably everybody's rethinking those right now." So don't be surprised if those happen. The A201 does deal with those two issues in some provisions that we're going to talk about in some detail now. It is a relatively unique right for one party in a contract to have a right to suspend a project or terminate a contract for convenience, while the other parties don't have that similar right. So, and what I mean by that is, in an owner-contractor agreement like our A201, the general conditions of that document, the contractors don't have a reciprocal right to terminate simply for convenience. There has to be a cause for a contractor to terminate or suspend their services. So there are some protections, of course, in A201 for contractors when that happens, and we'll talk about those as well. So let's first start talking about suspension and how that plays out in the A201. You find that language in section 14.3. There's two things to focus on here. It's the owner's right to suspend the project, but also and then of course the contractor's entitlement once that right is exercised. Section 14.3.1 talks about the owner's right, as you can see here from the language on the screen. It is a very broad right. The owner may, without cause, order the contractor in writing to suspend, delay, or interrupt the work in whole or in part for such period of time as the owner may determine. So, as long as the contractor is notified in writing by the owner, then this is an extra right that the owner can exercise for an unknown or a time period for which they determine. Now, the contractor's entitlement comes down in 14.3.2. It does allow the contractor to be entitled to an adjustment for increases in the contract sum and contract time. And also, those adjustments shall include profit. You can see that from the second sentence there. So, and procedurally, the way this would work out is, the contractor would let the owner know or work and communicate with the owner to let them know what those increases in contract time and sum are due to an owner's suspension. And then if the parties agree on those things, then to go ahead and execute a G701 change order. If the parties can't agree to those things, then the next logical step would be to go to the contractor presenting a claim. And we're going to talk about claims here in just a few moments, so hang on for that. Okay, so the next topic to talk about is what are the owner's rights to terminate the contract for convenience. You find that language in 14.4 in A201. I'm going to focus on three things here. The owner's right, again, it's very broad. Then we're going to focus on what the contractor's duties are when they are terminated for convenience. There's a few things that the contractor has to do upon getting that notice from the owner. And then lastly, when those things are accomplished, we're going to talk about what are the contractor's entitlement to when they have been terminated for convenience. 14.4.1 is where we find that termination right. The owner may at any time terminate the contract for the owner's convenience and without cause. Again, just as broad as the owner's right for suspension. Now, when the owner does when the owner does provide notice to the contractor's got to do three things, and you're going to find those in 14.4.2. The first thing that the contractor needs to do is cease operations as directed by the owner in the notice. If it is a notice to terminate, a part of the project, then to stop operations on that part. If they're going to terminate, the entire project, stop operations in accordance with that notice entirely. The second thing is that the contractor is required to take all actions necessary or that the owner may direct for the protection and preservation of the work. This is things like securing the job site, protecting materials that might be stored on the job site, those kinds of things to make sure that the owner's not going to be suffering any additional losses due to the work not being protected or preserved in some manner. The next thing that the contractor needs to do is to make sure that they terminate all existing subcontracts and purchase orders and to stop entering into subcontracts and purchase orders from the date that they get the notice. So those are all things to really, the idea is to really just shut down the entire project and stop the owner's liability for costs and any other fees or whatever that they might be incurring. If the contractor does those things, the contractor is entitled to a number of things in section 14.4.3. So, of course, as you could imagine, when the owner terminates the contractor for convenience, the contractor is entitled to work that is executed, is properly executed. Also, they're going to be entitled to costs due to termination. That's things like protecting the project, or all those activities that they were doing to protect the project, the work in place. The contractor will also be entitled to any costs that are attributable to terminating subs in any manner. So if there's fees that the contractor has to pay to terminate subcontracts or purchase orders, like restocking fees, any of that kind of stuff, all things that the contractor should be making sure to keep track of, and then they'll be able to get their costs for those items as well. And the last thing that you see in 14.4.3 that the contractor can receive is a termination fee, which we'll talk about on the next slide here. So the termination fee is something that needs to be negotiated between the parties, and it's not going to be included in the A201. You'll have to look at the agreement that is married up with the A201 in order to find that fee. You'll either want to look in the A101, A102, or A103, whichever document you used with A201 is going to have a prompt like the one you see on your screen for a termination fee. This is from A101, and it really is just an option for the parties to negotiate a fee for the significant inconvenience that it is for the contractor to have to abruptly stop work. They're giving up the possibility to do other work when they took the owner's job. So this is, it's a negotiation. Just make sure you look in A101 or your other owner contractor agreement to see if there's anything in there as well. So what are the contractor's rights to terminate? So far, we've been talking about, kind of the contractor in a situation where they're delayed. What are their options? The owner's suspension and termination rights for convenience. The next thing that I want to address is, if you've been just suspended for a really long time, does the contractor have any rights to terminate the agreement? And I want to underscore here that I am not going to be talking about every possible avenue for terminating the owner-contractor agreement. Certainly there are, if one party or the other has substantially not performed or materially breached the contract, there are avenues to terminate that owner-contractor agreement. But I'm going to be talking about all of those, and specifically talking about two things that may happen on your projects that are in A201 that are very, work stoppage or work suspension related. So the first one is you'll find in section 14.1, the first of our two avenues for contractor termination due to suspensions is in situations where the work has been stopped for a period of 30 consecutive days through no fault of the contractor. And you can see the highlighted language here in point 1 and point 2 are the things that I'm going to read because I think they're very applicable to a lot of you out there who are listening. So if you've got the 30 consecutive days, no fault of the contractor, and also for any of the following reasons: issuance of an order of a court or other public authority having jurisdiction that requires all work to be stopped. Governors, mayors who are requiring work to be stopped, these things I think would qualify pretty easily. Point 2 is very similar. It says an act of government, such as a declaration of a national emergency that requires all work to be stopped. Now, when I read this sentence, it says such as a declaration of national emergency. That's not the only act of government that could require a work stoppage. And in fact, I don't believe, I'm fairly certain that the national emergency declaration that we've had doesn't mandate that work be stopped. But you certainly could have acts of government through mayors or governors of your state who have required all work to be stopped. So I think either of those, there are really some overlapping ideas going on in those two sections. But I think a lot of contractors could find themselves here over the next few weeks in this situation. The next.
So Mike, I have a question while we're there for you, maybe to think about. I was thinking about when you were talking right there.
Yep.
This slide mentioned 30 consecutive days. So you might have contractors that are on this call or otherwise that have been, their work has been stopped, maybe for 15 days. So they're halfway through this 30 consecutive day period. If if you're a general contractor or you're in-house counsel for a contractor and you're halfway through this period, what types of things do you think like you'd be looking at and considering when you're essentially halfway to being able just to terminate your contract? I was sort of thinking about that as you were thinking, and I'm not sure there's a good answer for this one, but what do you think about that?
Yeah, no, it's definitely very real, because I think a lot of folks that are listening are in this same situation, and maybe they didn't know they would have this right. I actually struggled when we were putting this presentation together. I added these slides in here, and I was thinking to myself, like, do we really even want to talk about this? Is this relevant? I mean, it applies, but is this actually going to happen? Because if I'm a contractor, if I'm working for, a contractor right now, I'm not really thinking about, can I get out of my contract? I'm thinking about, when can I go back to work? And that's, my experience in dealing with contractors over the years is, if I'm a general counsel for a construction firm, I'm thinking about, how can I get back to work? How can I get paid for the delays that I've incurred, and make sure I don't lose a lot of money on that. I'm not really thinking, unless there's some other underlying cause that would make me want to get out of this contract, I'm not really thinking about, how do I get out of it? Because, contractors want to work. They want to get, especially if it's a project that's already been paying well and it's been a successful project for me, I want to keep getting those paychecks so I can pay my team. What do you think?
Yeah, I guess in hearing you kind of think through that, with me here just thinking out loud, I guess the typical economics of contractor terminations for work stoppages don't really come into play here, because usually it's because there's another project out there where you might be able to make more profit on, or something's going wrong on this one and you need to move all your forces around. Like you said, the focus, I think, for a lot of firms out there right now is they just want to keep working on whatever project they can. So even if they've been stopped for 15 days, it probably is not the kind of thing where this would be top of mind. So that makes sense. So that was my question. I appreciate you getting into that. I'll let you keep rolling.
Yeah, no, you're exactly right. It's like terminate this project and then do what? Once this epidemic or pandemic has passed, then you got to go out and find other work. So that's not a great position to be in. Good question. Yeah. So the other opportunity or the other possibility for contractors to terminate due to delays deals really with aggregated delays. The previous one was consecutive delays due to a governmental order of some sort. Section 14.1.2 discusses that if a contractor has been delayed through no fault of their own, again, and those delays aggregate to more than 100% of the total number of days scheduled for completion, or 120 days in any 365-day period, whichever is less. And when you look at that 100% of the total number of days scheduled for completion, that's basically another way to say the contract time. So if you, at the very outset of the project, you'd agreed to a contract time of 60 days, if you've had aggregated delays that are more than 60 days, that's your trigger. So that's another opportunity. 14.1.3 is where we get the contractor's entitlement. Again, you're noticing a pattern. It's the right, then the mechanism, and then the contractor's entitlement. And if a contractor does terminate and meets all the criteria that we've stated before, they're going to be entitled to compensation for work properly executed, for costs associated with termination, and then reasonable overhead and profit. So I'm just kind of trying to be a little bit aware of time. We are here at 5 after 1 o'clock. So Jimmy, I'm going to turn it back over to you, and maybe we can. I don't mean to speed you up, but I want to talk about owner architect issues here, and we got a few slides to go before we get to that. So I don't mean to speed you up, but I also do at the same time. So good luck with that.
Sounds like a plan. Yeah, I'm sure that's kind of the same instructions that all the contractors are hearing right now too.
Exactly. Speed up, but make it exactly as good as it would have been before.
Right. So again, quickly, we'll run over. So let's say you're a subcontractor sitting in on this webinar, and you're kind of saying, well, that's great, but what does all this have to do with me? Well, number one, all of the rights that we talked about are probably in your agreement if you're using an A401 somewhere. If they're not, we recommend that you take a look at Article 2. Article 2 is typically known as your flow down provision. Basically means that the terms and conditions of the prime contract between the owner and the contractor, they flow down and potentially apply to the subcontract agreement. So just understand how Article 2, the flow down provision, works. And as a result, your timing of submitting claims and the rights that you have to submit claims and all that might be affected by the prime contract. So that's a concept to understand for subs that are on this call. Everything we talked about potentially applies to you as well. So let's jump forward and let's talk a little bit about dispute resolution. So where we've been so far is we've talked about notice of claims already and what can trigger a claim. What can trigger a claim was that 8.3.1, and then how to provide notice. You've gone over that a little bit. And we'll talk about these other 4 issues down below notice of claims here that you're seeing on your screen. The first one that we're going to talk about is continuing contract performance. So continuing contract performance is set forth in section 15.1.4 of your A201. And all this says is that the contractor and the owner, both of them, have to continue to perform their contract obligations while a claim is being resolved. So I'm sure owners have had the experience where a contractor submits a claim and then says, I'm walking off the job unless you pay me. Or an owner submits a claim and the contractor says, I'm not working until you pay me. Or an owner hangs payment over a contractor's head and says, well, you submitted that claim, we need to work that out before you get paid anymore. That's not how Article 15.1.4 is set up. And just to understand, continuing contract performance is one of the mechanisms, and there are a few embedded within this and other contracts that put a premium on finishing the project on time. And that's the reason why continuing contract performance is in there. Another one of those mechanisms to finish on time is the inclusion of the role of the initial decision maker. So an initial decision maker is a party, usually it's the architect. By default, it's the architect in the AIA agreements, but the owner and contractor can agree to make it whomever they want, who essentially calls balls and strikes throughout the claim process as the project is going on the initial pass of these claims to keep the project moving forward. So I'm going to run through steps 1 through 4 here of how the IDM process works. And I'm going to use a quick hypothetical. Let me set this up because I think it might be relevant in the COVID-19 issue. So let's say you're a contractor and last summer you signed a contract to build a healthcare facility, right? So you're building a healthcare facility. Your initial substantial completion date was, midsummer of 2020, August 1, say. Well, 6 weeks ago, you got an order from the owner to say, this healthcare facility is very important now, way more than we thought it was going to be, and you need to be finished by May 1, right? It's an acceleration claim. It's an acceleration directive from the owner. Well, that acceleration is going to come with some increased costs. So as a contractor, you say, fine, no problem, we can get it done, we're here, but it's going to cost an additional $100,000. And the owner says, that's great. We agree that it's going to cost more, but we're only going to give you $75,000, right? So pause right there. Now you're at step 1. The owner and the contractor have a disagreement arising from or related to the project. So they disagree as to the damages, the cost of this acceleration. So then you go to step 2. Either the owner or the contractor file a claim with the initial decision maker. In this case, it'd probably be the contractor to say, hey, Mr. or Mrs. Initial Decision Maker, we think we're entitled to 100. The owner only wants to give us 75. Can you please issue a decision? So number 3, the initial decision maker evaluates the facts of the claim, and then they have 3 options. They can approve, they can reject, or they can state that they are unable to resolve the claim. In our experience, usually when IDMs are unable to resolve the claim, it's because they don't have enough information. So just make sure you provide them with enough information so they can do their job. And then number 4, the parties can, after they receive the initial decision maker's response, they can say, okay, we either agree with that and we'll move forward, or that claim can be subject to mediation or dispute resolution, which I'll talk about here briefly over the next couple of slides. Now, we would expect over the next couple of weeks and couple of months, potentially a couple of years, that initial decision makers are going to be very busy, more so than they may have been in the past. So if you are an architect or a consultant or an initial decision maker and you haven't acted as IDM in a while, the AIA just published an article entitled How to Manage Risk When You're Acting as an Initial Decision Maker. It's a helpful resource just to kind of go through a couple checklists on things to do to make sure that that process is being followed. And for any contractors listening, or owners or subcontractors who might think, well, that's not really relevant for me, it could be a relevant resource because you understand the things that an IDM are going to focus on as they go through this process. And the biggest one is making sure that they have as much information as possible. So as I mentioned earlier, mediation, it's sort of the next step in the process. If the parties don't agree with the initial decision maker's response, they can go to mediation. And mediation is basically a meeting between the parties. It's a non-adversarial setting. You sit down and you try and resolve your dispute, usually over the course of an entire day or two, and usually with somebody who's not really related to the project, either a retired judge, an attorney who's experienced in this area, a consultant, somebody who can sit down, evaluate the facts, listen to the positions, and go back and forth with the parties. If that doesn't work, then you can move to alternative dispute resolution, ADR. And ADR can then take the form of arbitration or litigation. The thing to remember is that the parties are going to share the costs of mediation and arbitration equally. If the parties choose to litigate, which they can, it's a checkbox in the A201, then litigation has fewer, like, quote unquote costs involved, that you just have to file it, but technically using a courthouse is relatively free. It's just the cost of the attorneys. So you want to consult with your attorney and make sure that you're evaluating the pros and cons of ADR and which one you want to select as you go into the process. And with that, Mike, I think I'm going to turn it back over to you and maybe talk a little bit about consequential damages.
All right, thank you, sir. So yeah, we're going to, now that we've talked about claims, we're going to talk about damages for all of about 1 minute. And then I'm going to turn to our owner-architect issues. So this slide's a little misleading. It should say waiver of consequential damages, because that is the contract provision that I'm going to be talking about. When it comes time to calculate damages or to argue over damages, they really fall into two different categories: direct damages and consequential damages. And direct damages are those that are directly related to a breach. They logically flow from it, and they're very foreseeable. So if you're a contractor and you've performed some work that's defective in some way, the direct damage that results from that is the cost to fix the work or the devaluation of the project in some way. Consequential damages, on the other hand, are things that courts will award if you properly argue them, but they are more tangentially related to a breach. They can be foreseeable, but they're much more difficult to foresee, and they certainly are the kind of things that can catch people a little bit off guard when they come time to be argued and discussed. So I always find it very helpful to think in terms of examples when it comes to direct and consequential damages. And in our owner-contractor agreements and in our owner-architect agreements, we typically have a waiver of consequential damages that is mutual, that both parties are going to be waiving them because they are very difficult for both parties to know and to manage risk associated with consequential damages, so at the very beginning of a project. So we certainly include that language in the A201. I'm looking specifically at 15.1.7, and consequential damages from an owner's perspective might be things like loss of use of a building or an income that's generated by a building or by a project. And as a contractor, you can imagine you're working for clients. You don't know how much income that project is going to should bring in for the owner. They probably won't tell you that information. So when you get when there is a claim for damages due to loss of income, it's going to come as a real big surprise because you have no idea how much that's going to be. From a contractor's perspective, that's things like costs for principal office expenses, including compensation of personnel that are stationed there, costs attributed to loss of financing. So those are standard waived in our agreements. And what we recommend that folks do in lieu of arguing over consequential damages after a breach has occurred is to negotiate liquidated damages to the extent you want to negotiate those up front at the beginning phase of a project when the contract is executed. Liquidated damages are a reasonable forecast of potential damages for things like loss of use, delay, those kinds of things. And so long as they are a reasonable forecast and it's not a penalty, courts will typically uphold those. So we encourage folks to think along the lines of negotiating liquidated damages in lieu of consequential damages. And now we're going to turn and talk about owner-architect issues. Certainly, contractors are not alone when it comes to feeling the impacts of the coronavirus pandemic and the social distancing and work stoppages that we've been talking about. It's certainly going to be a little bit easier for architects to work from home, but than a contractor. But you're going to be experiencing, delays in your services potentially. Suspensions of work are going to impact you just as much as they are a contractor in some ways. And of course, things like on-site activities, reviewing, punch lists, how to go out and do your substantial completion reviews and site visits are also very likely to be impacted. And in fact, we've had a few questions about those particular issues as well. So we're going to try and get into some of those. When we start to talk about anytime we talk about the architect performing their services and the manner in which an architect performs their services, we have to start by talking about the architect's standard of care. In the B101, this is language that you'll find in section 2.2. If you're looking at a B105 or a B104 owner-architect agreement, this same language is in both documents. B105, it's in Article 1, and B104, it's in section 2.1. And really the same principles apply to those agreements as well. The architect's standard of care states that the architect shall perform its services consistent with the professional skill and care ordinarily provided by architects practicing in the same or similar locality under the same or similar circumstances. And the architect shall perform its services as expeditiously as is consistent with such professional skill and care and the orderly progress of the project. So the standard of care is really the legal standard by which an architect will be judged when evaluating whether or not the architect provided their services adequately. And as I just quoted the language that's in B101, it is not a standard of perfection. It is, my shorthand for it is, an architect should act like their reasonably prudent peer in that exact same situation. So whenever you're faced with a tough call about, how should I deal with this design situation, or what should I be doing on a project from a professional capacity, ask yourself, what would my reasonably prudent peer do? And it is very situation specific. So some of the language that we've got highlighted on this slide, under the same or similar circumstances. Well, your peers right now are all going through the exact or very similar issues. There are social distancing guidelines, there are work stoppages, there are difficulties to get places and to be on site. So, so those are all taken into consideration when judging whether or not the architect has performed their services adequately. Also, the last sentence of the standard of care, which usually doesn't get as much focus as the first sentence, but the architect shall perform its services as expeditiously as is consistent with such professional skill and care. Now, I think a lot of you right now are probably thinking, because of all that has gone on, depending on your specific circumstances of where your project is and what is going on with your project in your area, are there arguments that perhaps things like site visits should be handled a little bit differently because the standard of care might mandate that or might allow that because circumstances have changed? Those are certainly possibilities. And is it also a good argument that the standard of care would allow my services to be delayed in some way because I don't have staffing, or because I can't do a punch list because I can't get onto the site, those kinds of things? I think those are all very good arguments. And we're going to drill a little bit down further onto those specific issues on the next slides. Section 3.1.3 is where we find the language in the B101 that discusses the schedule that the architect is supposed to prepare at the beginning of performing their services that does describe when and how their performance of their services are conducted. So the architect is required to put forth a schedule, and then I'm not going to read this whole thing, but I will read one particular line. It says, once approved by the owner, time limits established by the schedule shall not, except for reasonable cause, be exceeded by the architect or owner. Just like when we were discussing contractor delays, there are some good arguments out there, depending on your particular situation, that could warrant your services being delayed due to reasonable cause because of workforce shortages, delays, in being able to get onto a project site, or just the health risk of being able to get onto a project site to do things like punch lists. So again, they're all fact-specific inquiries, but I think there are some good arguments for delay of an architect's services, or an accommodations that might need to be made for an architect performing their services. Next slide. We know a lot of architects have written us and asked about, what are my responsibilities now to continue to do site visits, given that it's risky for me to go out to the site. The first language that we've got shown up here is the baseline expectation for an architect under B101 to visit the site. It's not, we do not specify an interval like every 2 weeks or every month. It is a flexible standard. The architect shall visit the site at intervals appropriate to the stage of construction or as otherwise required in section 4.2.3 to become generally familiar with the progress and quality of the portion of the work completed. And to determine in general if the work observed is being performed in a manner indicating that the work, when fully completed, will be in accordance with the contract documents. I've always took that to mean that, if the project is site excavation going on and there's just one trade on the site, I probably don't have to go all that much, not a whole lot going on. But once you've got 20 trades on the site, I might need to go out every 2 weeks or so and visit the site to keep myself informed and keep the owner informed as well. Right now, of course, if a project has been suspended in some way, does it make sense to go out to a project site where there's nothing going on? Probably not. That would, of course, that's very specific to work stoppage issues. So if what happens if you find yourself in a situation where work is still going on a project and it's in an area where there are a significant amount of infections, and while work is still allowed, but you're required or at least recommended that you socially distance yourself from others. What can you do when it comes to site visits, punch lists, and those kinds of things? Like I've mentioned before, I think you've got some pretty good arguments for, legal arguments for negotiating with your owner and the contractor to discuss alternate options for providing site visits and those kinds of things. But it's really important that, our recommendation is to communicate with the owner and contractor, let them know what issues you're facing. I'm an architect who's, immune compromised. I would have to ride the metro or the subway in order to get out to your site, and I don't feel comfortable doing that. In fact, it's recommended that I don't do that. And then, our recommendation is to agree to a solution that works for your project, get buy-in from the owner, and agree to whatever solution works for you and for the owner and contractor as well. And it could be a little bit more nuanced than either we're providing site visits as normal or we're not providing them at all. There are a lot of different options that I think folks should be thinking about right now. Is it possible to limit site visits in some way rather than go out less to the site, maybe bring less people out to the site with you, or even do things like conduct the site visits on non-working hours. If there's a time in the day where there's nobody there, and you can go out and visit the site with proper protective gear, maybe that's an accommodation that could work for all parties. And it's even possible, I suppose, to do things like virtual site visits. A contractor taking a video camera around and showing you work that's been performed, those kinds of things. I would caution though that whatever if you're doing things like video, digital site visits of some sort, you want to really get down to the details of what that's going to be. If I'm going to be sent pictures or just walked around with a video, what am I going to see? Am I going to see, every little stitch of the work? Probably not, but, am I going to see a sample of things that have happened, of areas of the work? But whatever it is, be very specific in what you are agreeing to as far as an accommodation for site visits or punch lists. And then above all, of course, commit it to writing. Don't just be happy with you had a phone call and you're allowed to do site visits after hours or maybe video conferencing site visits. Make sure you commit whatever that is to writing. And the option that you would have for doing that is take a look at our document G802. That is our amendment for professional services agreement document, where you can modify the language of the site evaluation that's in the expectation that's in B101. Now, Jimmy, I've just rattled off a whole lot of suggestions, and I'd like to get your thoughts on it, because these are things that I know you've been thinking about when you've been working with our AIA's risk management committee. You probably got some other, maybe even better ideas than what I just rattled off there.
Yeah, well, I would say, first of all, there is an article that was just published on the AIA's risk management website that addresses a lot of these issues. So in the interest of time, I probably won't go through a lot of them and just point people to that publication. And it's a very in-depth look as to what firms can do to minimize their risk, and this is sort of some of the things they can consider. I think that what you referenced in terms of committing everything to writing in a contract amendment is important, and really getting down into the details of how new site visits are going to work. For example, who's going to do the site visit? Is it going to be recorded? Is it not? Is it going to be during the day, during night? How long will it be? Will the architect have the ability to request certain areas be removed? If work has to be revealed and then put back, or whatever the case may be, and how that's all going to work. Another thing that I'll just kind of point out logistically, more for the purposes of this presentation, is I realize we only have a couple of minutes left. We also only have a couple of slides left, maybe 5 or 6 like substantive slides to go. So Mike, if you're okay with it, I'm good on time, and I think it'd be good maybe just to kind of keep rolling, and we'll kind of get to the finish line. And if we run 5 or 10 minutes long, I think this is important material that folks want to hear, unless you feel differently about wrapping up exactly at 1:30.
Oh no, I agree with you. My afternoon is open, so I'm just sitting at home talking. So let's keep going with it. I agree. I think my only appointment is my dog is staring at me, and he really wants to go for a walk. So Exactly. Let's keep going. It'll probably only be another 10 minutes or so, but we'll just kind of get through this stuff. And maybe when we redo this webinar on Monday, we'll be a little bit better with our timing. But thanks for everyone who's hung in there with us so far. I also think it's important to point out that one thing we do as attorneys is not only do we look at laws and contract language, we also want to look at things like precedent. And there's a whole volumes and volumes of legal precedent out there that help us interpret laws and interpret contracts and show us what's happened in similar situations in the past. The reason you hear us kind of, well, I think that'll work, it kind of depends, doing those kinds of things, there's just not a lot of precedent for what an architect is expected to do on a site visit during a pandemic. The best, that we can do is there are certainly some arguments you can make, and some things that you can point to from a legal perspective, from the standard of care and from that schedule of services language that I pointed out earlier. But there's not a case from 1972 or something like that tells us how a court would rule on these kinds of things. So that's important to pay attention to, is we're kind of inventing things as we go a little bit here. So next topic to discuss is, as an architect, you might be asked, you're always asked to do extra work that's beyond your basic services. That's always been my experience as an architect. You can contract to do one design, and you've got a homeowner that asks you to do 5 different variants, those kinds of things. But particularly when it comes time to discuss, pandemic issues. Given that context, you might be asked to do extra work that you didn't contract to do, and your compensation does not take into account. And I think the B101 Article 4 is your guide as an architect to dealing with situations where you've been asked to do work that is beyond your basic services. So take a look at Article 4 in a lot of detail. There are a couple of different types of additional services. I'm going to flag a couple that I think might come into play. The first example that I thought of is if owners are asking you to scale down a project in some way because their budgeting issues are, they're a little bit, they want to hold on to cash more, or they're not as comfortable spending the type of money on a project that they were a few months ago, you might be asked to, to readjust your design due to a changed budget in some way, or a budget that's been lowered. And if that's the case, you'll want to look at section 4.2.1, subsection 1. It does allow the architect to get an additional service compensation for services necessitated by a change in the initial information, previous instructions or approvals given by the owner, or a material change in the project, including size, quantity, complexity, the owner's schedule or budget for the cost of the work, or procurement or delivery method. So that could certainly come into play if the budget has been changed, if you've been asked to do a project that's smaller or change materials in some way. Make sure you follow the procedures that are set out at the very beginning of 4.2.1. You have to notify the owner with reasonable promptness. You need to explain the facts and circumstances giving rise to the need. And you need to get authorization from the owner before you start performing those services in order to get compensated for them. Another item that I did put up on the screen here is, it says, services necessitated by the enactment or revisions of codes, laws, or regulations, including changing or editing previously prepared instruments of services. We've had a lot of executive orders, what I'll just describe as those, been passed. We've also had stimulus package been passed. So things are changing from a legal perspective, and it's hard for me to think right now of all the ramifications that could have on an architect's drawings and specifications in ways they might need to be changed. But just keep in mind that there is a mechanism in the B101 and in a lot of our other B100 series documents that would allow for additional services if you're doing extra work that's due to the things that we've been discussing so far in this presentation. Okay, next, and Jimmy, I think I'm turning it back over to you to discuss owner suspension. Is that right?
Sure, yeah. So
okay.
Like Mike said, owners are likely going to be forced to suspend projects. So some questions that you might have are, what is the architect going to be entitled to? What's an architect options if an owner suspends the project? And one thing I'll do is pause here for a second before I get into the text of this article and say, suspension is something that is not directly dealt with on some of the other AIA agreements, other than the B101. So for example, I know I was looking at the A104, which is the abbreviated contractor agreement, and it doesn't deal with suspension directly. It's one of the clauses that was taken out to make it shorter and more streamlined. So parties to various owner architect agreements, owner contractor agreements, etc., if they want to deal with these types of issues and they're not in the base language of their contract, like Mike has referenced a couple times, the ability remains for the parties to enter into a change order or to otherwise modify their agreement, amend their agreement to include these types of provisions as if they were there the whole time. You just have to make sure that you adhere to, principles for appropriately modifying an agreement. But the next maybe 2 or 3 slides will touch on how to do that. So going back to the text of this slide, under 9.2, the architect is compensated for costs associated with the suspension. In this scenario, architects are compensated for the work they've performed, as well as expenses incurred in the interruption and resumption of architect services. So sort of thought of similarly to like demobilization and remobilization, so to speak, for the architect. Under 9.3, architects are given the right to terminate the contract if the owner suspends the project for more than 90 cumulative days and the architect is not at fault for that suspension. The architect can terminate in that situation if they just give 7 days written notice to the owner, and then they want to obviously comply with all the notice provisions in their agreement. If an owner terminates for convenience, then, what's the procedure? What's the architect entitled to? Let's look at some of those questions. And those are in 9.5, 9.6, and then 9.7, which is on the next slide. So under section 9.5, an owner can terminate an agreement for convenience at any time for any reason, as long as they give 7 days notice. If the owner terminates for convenience, then it's still responsible for paying certain costs, and those costs are set forth in sections 9.6 and 9.7. Those are the costs that you would typically think of that would be associated with the termination, even so far as the costs attributable to the architect in having to then turn around and terminate all of its consultant agreements. And you saw similar language when Mike talked about the owner's right to terminate the contractor. The contractor is entitled to similar reimbursement of costs. And then under section 9.7, the parties can agree to a termination fee, which can be just any amount or method for determining the termination fee, and then a licensing fee. So a licensing fee would come into play if the owner has terminated the architect, but intends to continue to use that architect's instruments of service in the completion of the work. The architect essentially licenses the intellectual property rights to those instruments of service to the owner for the remainder of the project. And that's set forth in section 9.7. So moving along to just a couple last minute items. So you might be a subconsultant and you've been sitting on this call the whole time wondering, how does all of this apply to me? Section 1.3 of your C401 agreement is similar to the flow down clause that we talked about earlier with respect to subcontractors. And you want to understand, number one, all of the concepts that we've discussed already probably come into play into your subconsultant agreement. You just have to find where. We were quoting from the B101, but those are likely still present in the C401 as well. And then also, if they're not, you might have additional rights and remedies and responsibilities via this flow down clause in your subconsultant agreement. So you want to be aware, number one, of this clause, and number two, of the prime agreement between the owner and the architect, because some of that language might come into play as well. And like we said before, if you want to modify your contract, the AIA offers some forms that you can use to properly and appropriately modify or amend those agreements. So the bottom two, the left and the right, are the ones that most people are probably familiar with, the G701 change order, and then the bottom right is the G701S, which is the subcontractor version. And the top two are the amendments to the professional services agreement, the G802, which I think Mike mentioned a couple of minutes ago. And then on the top right is the G803. That's your amendment to the consultant services agreement. So those are just some ways to modify your AIA contract documents that you might have to make sure that if you want to amend your agreement, that's one way to do it. The last big issue that we'll touch on here is just this one slide, and it's some insurance issues to consider. Now, I want to caution everybody that neither Mike nor we are not insurance experts. What we are doing here is just listing a couple of things to consider because some insurance might come into play with the COVID-19 pandemic. So the first thing to understand is that force majeure means something a little bit different in the insurance context. So we already talked about what it means in a contractor and architect agreement context. And all that is some event happens that potentially excuses performance for a certain period of time. In the insurance context, force majeure can either be an event that triggers coverage, insurance coverage, or it can be an event that prevents coverage. It triggers a denial of coverage, depending on the language of your policy, how the policy is worded. What most parties are familiar with in the construction industry are property insurance policies. So typically something like builder's risk that the owner is required to obtain a builder's risk is a property insurance policy. The thing to understand there is that a property insurance policy responds to property damage. In this instance, in all likelihood, there is no quote unquote property damage for a property insurance policy to respond to. Nothing has been physically damaged. It's just that you can't work, or your building has been shut down. You can't reopen. So property insurance policy likely is not your best bet. Similarly, something like business interruption insurance, which is actually contemplated in the AIA's suite of agreements. It's the Exhibit A to the A101, Section 8.2, letter A, point 2, offers the owner the option of purchasing business interruption and delay in completion insurance. That, however, also potentially only responds to property damage, or if property damage was the cause of the business interruption. So, for example, if you are you're a tenant in a high-rise, like you're an architecture firm, and you're a tenant in a high-rise commercial office building, if you simply have to close your doors, then business interruption insurance may not cover you. It might, but it may not, because there's been no physical property damage causing you to close your doors. If, on the other hand, the tenant above you has a water leak and you have to close because there are repairs that need to happen and your tenant fit out was damaged, that might be something that a business interruption insurance policy may cover. It's just you had to close for different reasons. So the thing to understand here, again, we're not experts on insurance, but you want to check your policy wording and then check with insurance counsel, your insurance agent, your insurance professional, to see if there is any insurance that you have in place that may potentially be triggered by a COVID-19 issue. It's just a prudent way to go forward, just to see you might have some protection for some aspect of some damages that you've incurred. And with that discussion on insurance, I can turn it back over to Mike to kind of close us out.
Yeah, thanks, Jimmy. I got two questions. Well, we've got a whole lot of questions, to be honest, and most of them we're not going to try to tackle right now, because a lot of these questions are very nuanced and very good, and frankly, I need a few days to think about some of them. So we might address them on our Monday webinar, which will also be online after it's presented as well. But two, right off the top of my head, someone asked the 30 days for contractors' right to terminate. Is that calendar days or business days? You'll find that in A201 under section 8.1.4, and it is calendar days. So there's an easy answer to that one. We had another person ask us about section 10.4 emergencies, which we didn't really focus on at all in this program, but I think it is something that I know I want to do a little Westlaw research on. Jimmy, I want to get your thoughts too before we close out. Section 10.4 says, in an emergency affecting safety of persons or property, the contractor shall act at the contractor's discretion to prevent threatened damage, injury, or loss. Additional compensation or extension of time claimed by the contractor on account of an emergency shall be determined as provided in Article 15 and Article 7. So I assume this is all in the context of a project that has not been stopped, but the contractor is concerned about the safety of their personnel and continuing to bring them on the job site. I personally, I think this, I would assume that this provision has been, we'll have some court guidance on how it's been used in the past. It seems like it might apply here. Jimmy, what do you think?
Yeah, I think potentially, talking about A201, you said 10.4?
Yeah, and it's one we haven't talked, yeah.
Sure, yeah, I think section 10.4, if you read it in conjunction with the, like section, Article 15 and Article 14, the claims provisions, I think section 10.4, because the contractor has a contractual obligation to ensure job site safety, then if they're acting within that contractual obligation for job site safety on an emergency basis, and that would likely be the trigger, is whether or not it's an emergency, then the language of 10.4 might come into play. So it's something to consider. I can think of a scenario, for example, where you know, it's 2 p.m. on a Friday, and the governor has just issued a shutdown order that all construction projects must stop by 5 p.m. You know, that contractor is going to incur some costs in an emergency where they have to shut down and clean the site, protect the site, et cetera. Those might be the kinds of things where courts may allow that, but then I would imagine at some point the emergency would cease to exist. There's no longer an emergency, so a contractor would have to show. My guess is that the case law would further clarify this, but the contractor would have to show these particular expenses were as a result of the emergency, and then the rest of these were, you know, other expenses that we incurred. So that would be my guess. But 10.4 is something that I kind of noted in going through this to say, because a contractor has to preserve job site safety, then if they have to do so on an emergency basis, then 10.4 may be triggered. But again, I would consult with counsel and see if they can give you any guidance on how that issue has been interpreted in your state in the past.
Right. Yeah, I agree, and we'll look at that one and talk about it a little bit more on our Monday webinar. So if you're listening to this in the future, check in on the Monday webinar, and we'll discuss that in a little bit more detail. So we do have more questions, but we'll have to. I think we're getting on to 2 hours right now. So and they probably require us to do a little bit more thinking and putting our heads together. So. So we can go to the next slide here. The thing that we wanted to really drive home for folks is that communication is key, and you're going to have a better outcome in your projects if you are communicating with the owner and contractor and architect all together and coming up with solutions. Certainly, your contracts are going to give you a guide to your legal rights and remedies and some procedures, but communicate and always, you know, document and everything, and certainly amend your contracts as appropriate to take into consideration the new realities that are on your project or any agreements that you come to. And we have a number of resources up on our webpage. If you go to aiacontracts.org, we have a learn page. We can see all of our contracts. You can see samples of them. You know, before you purchase them. You can also call us or email us at docinfo@aiacontracts.org. There's the telephone number there if you have contract questions, you know, about the content. Again, can't provide legal advice on any of this kind of stuff, but we can tell you about AIA contracts and how we intend them to work. Lastly, I'm supposed to remind everyone that this is you will be getting this webinar, the recording of it, and the presentation itself by the end of the day, I think is what we were shooting for. If not then, by tomorrow. Also, if you are looking for your health, safety, and welfare learning units, if you're an AIA member, you should see those on your transcript in a couple of weeks. If you registered for this program properly, you'll be able to see those. If you don't get them, just shoot us an email. Shoot us an email at either docinfo, or you can contact someone in our office named Hosky Hijazi. She would be happy to help you out with all of those things. Anything else, Jimmy, before we break?
No, Mike, I think you did a great job. I would just thank everybody. I know these issues are top of mind for everyone. So we will continue to evaluate questions that we receive, information as it's appropriate, and then if there are specific things that we think enough people are concerned about, you might look for additional content coming out of the AIA regarding specific issues to look out for, contract terms that, you know, a lot of people have questions about, things like that. So I would say if you have questions, submit them and keep a lookout for additional content. And thank you for your time. I know we ran a little bit over, but we understand this is important for everyone. So thanks very much.
All right. Thank you, Jimmy. And we'll close it out at that. Take care, everyone.